Public Protector Busisiwe Mkhwebane's bid to reverse the Estina judgment and the cost order has failed in two courts. Last year, a High Court ordered the Office of the Public Protector to pick up most of the legal costs. In Mkhwebane's appeal, she was also ordered to pay 7.5% of the costs out of her own pocket. In a scathing judgment, Judge Ronald Tolmay branded Mkhwebane's report into the Freda Dairy Farm scandal unconstitutional and invalid. What now for the Public Protector and the reputation of the office? Let's talk about this with Michael Osborne, a constitutional law expert from the University of Cape Town. Very good morning to you. Talk us through what happened yesterday and how important it is.
Good morning to you. What happened yesterday was that the Supreme Court of Appeal in Bloemfontein decided to reject an application for leave to appeal from the Public Protector, in which she would seek to have the SCA reverse the decision of Judge Ronald Tolmay, in which she did two things. First, she set aside the Public Protector's report on the Estina farm matter, and secondly, as you prefigured a moment ago, she was ordered to pay a significant proportion of the DA's costs in the matter.
All right, so what can she do now? Can she appeal?
Yes, she can approach the Constitutional Court. She can't appeal as of right. What she can do is she can approach the Constitutional Court and ask the Constitutional Court to grant her leave to appeal.
All right, where does this leave her and justice when it comes to this case?
Well, it leaves her in a politically embarrassing situation. The proceedings in Parliament to have her removed continue, and one would think that this would be yet another in a series of legal battles that she's lost, that would be used by those in Parliament who want to displace her. Legally speaking, what it means is that her report is set aside in its entirety. It's a nullity. Effectively, I understand the report was attacked by CASAC and the DA back in 2018 because it was said to be a whitewash, in the sense that it let leading politicians and the Guptas off the hook. Now, in principle, that may now change anyway, because the Public Protector, after Judge Tolmay's decision, announced that a second report would be coming out, and that this second report would indeed look at those higher up who were alleged to be in some sense culpable. Now, that report, I think we heard not too long ago, was in the pipeline. So it may well end up, we would end up with this odd situation where her first report was found to be inadequate, rendered a nullity. It would now be substituted by a new report, which may or may not be more comprehensive. But no doubt that new report will itself be attacked by those that it names. And so the matter will proceed.
But if she is still there, because there doesn't seem to be the appetite to get rid of her, you wonder how many losses she needs to suffer. I mean, will that report be handed over in its entirety? How much fiddling possibly could happen?
When you say that report, you mean the new report,
yes,
which is said to be in the pipeline? Well, indeed, that one can only speculate what will happen to it. It was promised. News reports in the last few weeks, I said indicated that it was coming. So I suppose we will see it, but we wait with bated breath to see what it says.
In March, the High Court found the Public Protector lacked a basic understanding of the law and its application. I mean, if you don't have that, and you talk again about her losses, what sort of impact is this all having on her office?
It has a negative effect on her office. What Judge Tolmay said last year, and a couple of other courts have said is that as a Chapter 9 institution, the Office of the Public Protector is utterly central to our constitutional setup. And quite irrespective of the personality who holds the office, if one has a situation where in almost every case that one of her reports is litigated, it is set aside, and that the decision setting it aside is accompanied by a personal costs order, the effect is to degrade the institution and to take away one of the props of our constitutional order.
Let's leave it there, Michael Osborne. Thank you.